All right, fine. So the next topic which we were having is on pleadings. So we will discuss that part. Pleadings, generally, it is order 6 of the CPC, and there are 18 rules that we have. Okay. So few of these things we have discussed while discussing this topic from Unit 1, institution of suits as well, because suit would be instituted again by with the pleading only, right? It starts. So there also we had discussed few points, but on pleadings we have like a complete topic which is dedicated on this only. So we will see that there are total 18 rules that we have in order 6 of CPC. So when we talk about pleadings, like when we talk about like institution of suits in general, it starts with submitting the plaint or the written statement. Like the person who is filing the case, he would submit his plaint, which is very important to narrow down all the claims that the person is making. So that becomes very important, and on the basis of what plaint has been submitted, the defendant gets to know what are the charges or allegations that are being made. So in such a way, like pleading would include both the plaint as well as the written statement, what is being filed by the petitioner plus what the defendant replies, both the things would be included. Now in institution of suit, we have already studied that pleading will contain only material facts and not the evidences, because evidences would come at a later stage only, where parties will take help of those evidences to prove their point, to prove the case. So when we are just submitting the pleading, we are basically narrowing down our claims, that these are the things or these are the allegations that we want to make. So it's very important that we are not talking about evidences, we are not talking about the law which is there, we are not talking about precedents as such, but only the material facts. But now, what is material fact? That is again like not that much clear, right? So for that, we have these two cases. Okay, first one is Uddhav Singh versus Madhav Rao. It is a case of 1976. So this case was filed under Representation of People's Act. Actually, both these two cases are under the same act, Representation of People's Act, under related to election matters. Okay, so in the first case, what happened is that allegations were, like there were certain allegations made, but those allegations were not related to the material fact. Okay, allegations were something and material facts were something, particulars were something that did not constitute a complete charge of corrupt practice of the act. So the allegations were that the person is liable under Representation of People's Act. He was involved in some kind of corrupt practices in terms of elections. Okay, that point they have mentioned, but what facts were being produced, those facts are nowhere related to or nowhere indicate that the person was actually involved in some sort of corrupt practices. Like you don't need to give evidences as such, you don't need to prove your point like beyond doubt, but at least you need to provide some material facts. Like if you are filing a case for recovery of money, all right, if you are filing a case for recovery of money from a person, at least you need to mention that this person has taken such an amount from me on this date, the person promised to return it on so and so date. At least that thing should be mentioned. Like we need to at least give some points, right? That would not like prove the case, but some material facts, like when money was taken, when it was promised to be returned, those things need to be mentioned in the pleading. So those will be nothing but some material facts. So what are material facts? They are nothing but facts that are required to prove the allegations made. That it is, yes, money was taken, that's why I'm filing this case for recovery of money. Like that, it has to be there. As the pleading in the case, in this case was so not related to the material facts, this petition itself was dismissed. Court said that we are not entertaining this matter because yes, you are making allegations that the person has violated this legislation, but as such, you have not mentioned or you have not provided enough of material facts that supports your allegations. Okay, this is clear, right?
Yes, ma'am. Can you just summarize one more time?
Okay. So mainly, what is material fact that we need to understand? Material fact basically means you don't need to prove your point 100%, but at least you need to support the allegations that you are making. If you are filing a case saying that this person has violated provisions of Representation of People's Act, at least you provide some facts. Okay, if you are not providing that, that means it's not material fact is not being provided. And that was the same reason why this case in itself was dismissed. Court did not entertain the matter that you have not provided the necessary or material facts in this case. Okay. So same ways, there was one more case, which is Virendranath Gautam versus Satpal Singh, which is a case of 2003. Actually, the matter took place, and this case finally was cited in the year 2005. That's why we see 2005 here. Now, it was like a case before Supreme Court of India, which was filed as an appeal. Okay, civil appeal, the case was filed. Why this case was filed is because the appellant, as in Virendranath Gautam, had filed a case in Himachal Pradesh High Court, again relating to some election matters. He had filed a case. Okay, he said that both Virendranath and Satpal, they both were candidates in some election. Virendranath was from the Congress party and Satpal was from BJP. And they, this party from the BJP candidate, that person won the election just for a small margin of votes. It was just for 51 votes. This person won the election. After that, Virendranath Gautam filed a case in the High Court saying that there were some irregularities in the election. Okay, this EVM machines which were used, those machines were defective. There were some void votes. Okay, there were some void votes which were being filed. In the name of that person also votes were being given. There were cases of double voting. So because of all those things, I challenge this particular election. There has to be recounting. Okay, reassessing of the result has to be done. Like that, Virendranath Gautam had filed the case. But when seeing this, the plaint which was being submitted, right, High Court said that you have not provided the material facts. The necessary information is not there in the plaint which you have submitted, and that's why we are dismissing this petition. Okay, so you have not provided the material facts, so we are dismissing this petition. We are not hearing this matter. Just because you lost the election for 51 votes, that does not mean that there has to be recounting. So we are dismissing the case. Now, Virendranath Gautam was aggrieved by this decision of Himachal Pradesh High Court, and he decided to go to the Supreme Court, file this appeal. And before Supreme Court, there were these major questions that they had to decide. First of all, whether the election petition does not disclose any cause of action. Is it true that this the pleading which is being submitted that actually do not disclose the cause of action? Like, what is the main problem? Why this person has filed the case? Is it because he lost the election, or is it because there were some irregularities, or what was it? Is it really that in the pleading cause of action was not very much clear? Secondly, whether the petition lacks in material fact and particular, whether we need those material facts or not, and those were mentioned or not, that also court had to see, Supreme Court had to see. And lastly, whether the petitioner is stopped from claiming recounting of votes. Just because he lost the election, was it the only reason why he was asking for a recounting? And as such, was the High Court right in saying that recounting is not possible? This case is only dismissed. So basically, Supreme Court had to take a decision on whether High Court was right in taking that view or not. High Court was right in dismissing the case or not. Okay, so mainly High Court said that, okay, fine, you have made allegations that elections were illegal. You have said that for some dead persons also votes were being taken. But when did you came to know this? If for in the name of some dead persons, votes were being taken, when did you came to know it? Was it during the polling time only you came to know? Was it that afterwards you came to know? How did you come to know? All these things you have not mentioned in your pleading, and that's why it is lacking in material facts, and that's how High Court dismissed the case. Okay, and they said that simply because you have lost the election, recounting is not possible. Like that, the High Court dismissed the case. But Supreme Court was not satisfied with this view that High Court had taken, and Supreme Court said that no, this petition, right, whatever this pleading is, in the pleading, the person has provided all the material facts. He has said that there were irregularities. One second. Okay, so there were irregularities. Some for some dead person also votes were taken. Some people have done voting 2 times. EVM machines were not working. So everything is mentioned in the pleading itself. What is lacking is how did the person come to know it? When did the person come to know it? Those are not necessary as such to be mentioned in the pleading. Okay, so Supreme Court was of the view that High Court's decision is not proper, and Supreme Court said that what we are doing is we will restore this particular application, and High Court need to look into this matter one more time and give a proper decision. And because it's related to election, already a lot of time has already passed. High Court need to take up this matter on priority and give a decision on it. Okay, so what is material fact, what is not material fact, it has to be seen properly by the court also. Simply because some minute details were not being provided, it does not mean that material facts were not being mentioned. In this case, it in fact was mentioned by the petitioner. That's why Supreme Court said that no, High Court need to take up this matter one more time, and they need to like provide a proper decision here. Okay, and one important thing that Supreme Court had mentioned is like in facts also, right? Whatever fact or information we provide, facts are also classified in 2 groups. One is facta probenda, another one is facta probentia. So this case is also important because it classified facts in 2 different like groups for us to understand it properly. Facta probenda means the facts which are required to be proved, that is material fact. That means whether the election was irregular or not, whether EVM machines were actually not working properly or not, whether there were double voting or not, whether in fact in the name of some dead person somebody voted or not. These are nothing but some facts that needs to be proved, and they are facta probenda. On the other hand, facta probentia means those facts with which facta probenda may be proved. Like those minute details, how we can prove that actually there were irregularities. Right? So the person did not mention that, okay, fine, there were, like when did he come to know about the irregularities, how he came to know. Those things are not facta probenda. Those are rather facta probentia, which will be proved at the different, like after the case starts, there only it will be proved. So in the pleading, what we need to mention is we need to mention facta probenda. What are the facts that should be proved before the court, not facta probentia. As in, we don't need to prove what all things, like how we came to know about it, how we derived a certain conclusion. Those things need not be there. So these are 2 types of facts which were classified by the Supreme Court in this particular case. Okay, so main distinction is what are the facts that needs to be proved, that we need to mention in the pleading, but by what means, with the help of what other facts we would prove, that thing we need not mention in the pleading, because it's somewhat like an evidence only, right? That we came to know by this way, that way. Those need not be mentioned in the pleading. Okay, so next one is Rule 3 that talks about forms of pleading. So in CPC, certain forms are being mentioned, and when we file a case, right, when there is a pleading that is being filed, it has to be in that same format only. Like if we look at, if we look at this appendix A, talks about pleading, forms of pleading. For title of suits, we need to file in this certain format. For money lent, we need to file this format. Money overpaid, sale, goods sold at fixed price and delivered. Like that, we have lot of different forms or templates being provided. So we need to see which format is relevant for us, like what kind of a case we are filing, and based on that, we will file the pleading. Okay, based on this given format only, we will file the pleading. So there are so many different types of cases. Indemnity, procuring property by fraud, polluting water, carrying on noxious manufacture, obstructing a right to way, diverting water course, injuries, malicious prosecution, movables wrongfully detained, recession, injunction, public notice, interpreter. We have so many different types of forms being mentioned. So most likely the matter would fall under any of these different types which are being mentioned, like types of suits. If it is falling, we need to mention in that certain format only. Okay, so
any one example, ma'am, can be considered for the format.
Yeah, for the format, okay. Yeah, so take for example, this is for title of suits that we can consider. One second. Okay, so for title of suits, that in the court name would be mentioned where the case is being filed. ABC party name will be filed. He is the plaintiff, versus defendant's name would be mentioned, that he is the defendant. Then description of parties in particular cases. And then we have rule 3 that talks about forms of pleading, wherein different forms are being mentioned in appendix 1, that it has to be filed in this certain format only. It is just to ensure that parties stick to the basic, like, necessary information. They do not drag all the other irrelevant things in the pleading, because it would become otherwise very difficult to narrow down the claims and stuff. So we do have a format for most of the different types of cases. It has to be followed if a format is there. If not, some format which is nearly as maybe similar in character, like that we would decide and we would file a case. Because there are so many different types of civil suits, it might happen that a certain different format is not being mentioned. So in such a case, we can just file it in some format which is like as closely as possible, same kind of a matter. Okay, same ways for commercial courts, sometimes format may be given, because high courts may make certain rules or provisions. If high court has mentioned any certain format or any certain way is being prescribed, then we need to follow the same process. In that same way only, commercial disputes will be like instituted. They would write the pleading in that same format if we have a format which is prescribed by the high court for commercial courts. Okay, particulars to be given where necessary. So in all cases in which the party pleading relies on any misrepresentation, fraud, breach of trust, willful default, or undue influence, and in all other cases in which particulars may be necessary beyond such as are exemplified in the form aforesaid. Particulars with dates and items, if necessary, shall be stated in the pleading. Now, in the pleading, it would be like a standard format or standard template, how it is being mentioned. But then parties may feel like, okay, fine, I am filing this case for maybe possession of property, for declaratory decree, or for title. But then apart from that also, apart from title also, it is a case of misrepresentation, fraud, breach of trust, based on which the party did not give me title or did not give me possession of property. So if they are claiming any of these things, some other materials might be there, right? So with date and with dates, the items which are necessary, they can produce it. So sometimes it may happen that there is a contract between two parties and one of the party is not performing his part of contract. So with regard to that, if it is like willful default, the party has willfully not performed the contract, it's not like some situation has taken place or anything like that. So in such case, the party may provide such necessary details as well, particulars of those points which the person is claiming or mentioning in the pleading, those also may be provided by him. It will be stated in the pleading. Okay, next one is condition precedent. So what is condition precedent? It's basically like in contract, we actually get a provision. Okay, so condition precedent as in, say, take for example, there is like a contract between two persons, A and B, and it talks about performance of some duties. Performance of some duties. Now, it is in such a way that one will come, okay, one of the duties would come, after the second one would come, after that only third one would come. Like there is like a sequence of events, how it has to happen. So if it is something like this, that means second duty would be performed only when first one is performed. Third duty will be performed only when first and second are performed, right? So this is nothing but condition precedent. Like take for example, if we are ordering something online, maybe we would say, okay, we are ordering something online. Option we have selected is cash on delivery. Over here, it's nothing but a case of condition precedent only. Right? So take for example, we are ordering something from Amazon. The first thing that comes is for Amazon to pack and ship the item, whatever we have ordered. After that, I need to make the payment, COD. After that, delivery would happen. After that, delivery would happen. So take for example, I have made the order, I have selected cash on delivery, but what I'm saying is, I'm not going to pay the money, but you deliver the item to me. In such a case, definitely the delivery person would say that I'm not going to deliver it because there is a condition precedent, right? First of all, I need to make the payment. After that, only he would deliver. So this is nothing but example of condition precedent. Okay, sometimes it may happen that there may be like a contract between two persons wherein they will say that I will, like I'm interested to send my plot of land to you for maybe 30 lakhs rupees. But what you need to do is you need to pay 2 lakhs rupees advance for me to trust on your words and keep this property for you. If you are not paying 2 lakhs advance, I can sell it to any other person who is interested. Okay, so here if I'm not paying 2 lakhs rupees, I cannot file a case against this person that he violated the contract because it was condition precedent. I had to do something, after that only I claim for it. Okay, so it says any condition precedent, the performance or occurrence of which is intended to be contested, shall be distinctly specified in his pleading by the plaintiff or defendant as the case may be, and subject thereto an averment of the performance of occurrence of all such conditions precedent necessary for the case of plaintiff or the defendant shall be implied in his pleading. So if I'm saying that, okay, this person is filing the case for maybe no breach of contract, but then there was a condition precedent. The person only did not perform it. Okay, or sometimes it may happen that there is like offer of performance. This again is from Indian Contract Act only, where it says that maybe I have offered to perform my contract, but the other person did not allow me to perform the contract. Okay, like that 2 lakhs rupees, which I was saying, advance amount. I went to the person to make the payment, but he only was like, no, today I'm not available. Maybe after 2 weeks, you make the payment. And then he sold it to someone else. Okay, that means condition precedent. It's not my fault, but other person only did not do the condition precedent. That's why it has happened. Okay. This is clear, right?
Yeah.
So next one is departure. No pleading shall, except by way of amendment, raise any new ground of claim or contain any allegation of fact inconsistent with previous pleadings of the party pleading the same. The main purpose of pleading in itself is that we want to narrow down the claims, or we want to narrow down the allegations which are being made. Like we want to make it certain that, okay, these are the 5, 6, 10 points or the 10 allegations that the person is making. So it is very important that the person do not do it like in the pleading he has mentioned something, in the court he is saying something completely opposite. He had claimed for something, in the court he is saying something completely opposite. So that should not happen. Any changes will be possible only by way of amendments. The party cannot just do it on their own interest. Okay, whenever they want, they cannot make any changes, whether it is in terms of the allegations or it is in terms of the ground of claim. What right are they claiming? Because in a civil suit also, we would see there might be like multiple rights or multiple remedies available to the party. So which remedy is the party claiming? Which claim is the party asking for? It has to be same as mentioned in the pleading. It should not be something completely different. Next one is denial of contract. So where a contract is alleged in the pleading, a bare denial of the same by the opposite party shall be construed only as denial in fact of the express contract alleged and or of the matters of fact from which the same may be implied, and not as a denial of legality or sufficiency of law of such contract. Sometimes it may happen. Okay, so denial of charges in the plaint implies denial of breach only and not regarding validity of contract. Sometimes a person may file a case in the court saying that there was a contract between me and this other person, and the other person has violated the contract, there is breach of contract, so and so clauses were not being performed. If the other person denies to those allegations, it only means that he is denying with regard to breach of the contract. But he is not denying as regard to validity of the contract in itself or existence of the contract in itself. Okay, so when there is denial, court would assume there is denial regarding the alleged breach of contract which the other person has mentioned in the pleading. Based on that, court would ask for maybe evidences, or the persons would be examined. So person can say that, yes, I did offer for performance of the contract, right? I did offer for performance of the contract, but other person only did not allow me to perform the contract. That might also happen. So denial of the contract is Rule 8. Effect of document to be stated. Wherever the content of any documents are material, it shall be sufficient in any pleading to state the effect thereof as briefly as possible, without setting out the whole or part thereof, unless the precise words in the document or any part thereof are material. Sometimes, like contracts between two individuals or organizations, it may be like a very bulky document also. Apart from contract, there may be certain amendments or other things done to the contract also. So in such a case, It's not needed that this entire document or material of entire thing is submitted along with the pleading. What is necessary is effect of document to be stated. That there is a contract between the parties. But what is the effect of that contract? Only that is enough to be mentioned. Like it has to be very brief. They don't need to give content of the entire document or entire material. So what they need to provide is only the effect of that document. Okay, take for example, there is a contract, and under that contract, there is an obligation to supply raw materials by one person to the other. In such a case, they may simply mention that under so-and-so contract, there is this obligation to supply raw materials, which was not performed by the party within the promised time frame. But it might not be necessary to mention all the other details, like in what intervals, what was the amount charged, compensation, other obligations. Those things might not be necessary. So what is the effect of this document? Because of this contract, effect is that you need to supply raw materials which the person failed. So only that much, if we mention, that is only enough. Same ways, if we are saying that there is like a sale deed and there is an obligation to hand over possession under the sale deed. It's enough that we are mentioning that there was this sale deed which was executed and person has not given possession of the property. Based on the sale deed, one part is still not being performed. Just mentioning that is enough. We don't need to mention or provide all the other materials that we have with regard to this sale agreement. Okay, those things we may produce at a later stage, but ideally those are not needed unless and until, okay, unless and until the precise words of the document or any part is material. Sometimes it may happen that there is a contract between two parties and some precise words in that contract is like very important for them to prove their point. In such cases, we may mention, like there may be a contract between two parties wherein one clause says that in a contract, like it is regarding automatic renewal of the contract every single year with 10% price rise. If there is such a clause, based on that clause, if something is being demanded, then the party may say that yes, there was this certain clause being mentioned and it talks about automatic renewal. Plus it talks about 10% price rise also. That's how it is very important for us. Like that, if something is very much like material, only in such a case we need to provide. Otherwise, we don't need to like provide all the documents, materials, whatever we have along with the pleading. Okay. All right. Next one that we have is malice, knowledge, etc. Where it is material to allege malice, fraudulent intention, knowledge, or other condition of mind of any person, it shall be sufficient to allege the same as a fact without setting out the circumstances from where it is being inferred. So just mention that this is what has happened and this is what I am claiming. That is enough. How you came to know about it, how it was being proved, what all situations happened, those things can be mentioned at a later stage. So like we have said, right, evidences are not necessary. Same ways, how we inferred a certain thing, that is also not necessary, because that might again narrate an entire story of like few months or few years also. So those things would not be necessary to be mentioned in case of the pleading. Okay, so malice or knowledge, etc. You don't need to mention it in detail, how you inferred from what situation, but just mentioning it as a fact is only enough in the pleading, so that the other person knows that, okay, these are the charges, right? It talks about bad intention also, intention also as a point in the pleading. So that has to be there. So next one is notice. Wherever it is material to allege notice to any party of any fact, matter, or thing, it shall be sufficient to allege such a notice as a fact, unless the form or the precise terms of such notice or circumstances from which such notice is to be inferred are material. Sometimes it might be necessary that you need to submit a notice before like filing a case. If it is something like that, that you need to submit a notice, there is like a prescribed form being provided, time limit being mentioned, then you need to do it in that particular way only. Like section 80 of CPC, it talks about sending at least 2 months prior notice to the government if you want to file a case against them. So if there is some that kind of provision mentioned, that kind of procedure mentioned, we need to follow that. We need to provide the required notice before filing of the pleading. Okay, so Rule 20 talks about implied contract or relation. Sometimes like contracts might be implied or express as in properly in a written form, it's there, but sometimes it may be implied. Maybe there is no written documents as such to prove it. Okay, that might also happen. So what would happen in case of implied contract or a relation? Sometimes some relation also might be parties are not having like any documents as such to prove, any certificates as such to prove, but it exists, implied relation. Like implied relation of maybe principal and agent. Someone was working as an agent of the other person. Okay, so those cases, how it has to be done. Implied contract or relation. As such, there might not be an agreement of agency between two persons, but in fact, there exists this agency relationship. So those would be implied relation. Whenever any contract or any relation between any persons is to be implied from a series of letters or conversations, or otherwise from a number of circumstances, it shall be sufficient to allege such contract or relation as a fact. So there may be series of emails which the principal had forwarded to the agent had replied to the principal. Like that, it might be series of letters or conversations that prove the point that there in fact was an implied contract or an implied relation between these two persons. In such cases, it's sufficient that you just mention it as a fact in the pleading. Okay, those contract or relation as a fact you can mention. And to refer generally to such letter, conversations or circumstances without setting them out in detail. You can simply mention that there were 5-6 conversations, email conversations by which the principal has given me the authority to do this thing on his behalf. So just mentioning it as a fact is only enough. We don't need to provide entire details and what all inferences we made, how we thought about it, what other people thought. Those might not be necessary in the pleading. And if in such case, the person so pleading desires to rely in the alternative upon more contracts or relations than one as to be implied from circumstances, he may state the same in alternative, unless and until there is like some specific situation, some specific thing, the person can just simply mention there were these conversations. But if there is like some specific one whereby he was expressly like given the power to take a certain decision, he may say that, yeah, there were all these email conversations, and in this certain one, he did ask me to perform this work for him. So I thought that it is like an agency relationship. Based on that, I'm making these claims in the pleading. Okay, so in normal situations, these things will be sufficient if it is mentioned as a fact only in the pleading. Later on, court would see what all proofs the person is having and would take a decision based on merits of the case anyways. Is this part clear? So, Rule 12?
Yeah, madam. Yeah, clear.
Next one talks about presumptions of law. Sometimes what happens, right? Law also may presume certain things. Okay, like in the general rule is that we need to prove a certain thing 100%, like beyond any reasonable doubt we need to prove. Otherwise, law may even acquit the person, that his guilt is not proved beyond reasonable doubt, so we are acquitting the person. That also happens many times. But there also may be certain situations where law presumes certain things. Okay, so what will happen in that case? Presumptions of law. Neither party need any pleading allege any material, any matter of fact which the law presumes in his favor, or as to which the burden of proof lies upon the other side, unless the same has first been specifically denied. For example, consideration for a bill of exchange. Bill of exchange, are you aware?
Yeah, madam.
When a bill of exchange is nothing but sort of, we can say, like a contract only. Okay, what happens in bill of contract exchanges? A person would say that I will pay you 5,000 rupees, or he would order the other person, right, that you need to pay me 5,000 rupees on so and so date. Might be on 3rd of February, you need to pay me 5,000 rupees. Now, when there is such a bill of exchange existing, and in bill of exchange, always the other party would put his signature. Okay, so if you are having possession of a bill of exchange wherein you have ordered me to pay 5,000 rupees to you on 3rd of February, plus I have also put my signature in that bill of exchange, in that case, court already presumes that I have received some consideration for that. Might be you have provided me some service, something you have supplied. That's why I agreed to pay you 5,000 rupees with my signature. So in such a case, when law is already presuming it in your favor, that I have received some consideration, you don't need to prove that thing in the pleading. Okay, because law is already presuming it in your favor that you have already given the consideration. Now it's my turn to pay the 5,000 rupees. So that might not be needed because it is like repetition of the same thing. Court is already presuming it.
It's just like section 130, 139 of NI Act, madam.
139 of NI Act. Yeah, like sometimes it might happen that sometimes a person may even give a check like before taking the service also.
So it's presumption law is more or less meaning to that, isn't it?
Presumption law, you can say this bill of exchange thing, you can say, plus there is also presumption. If you talk about criminal law, there is one presumption that if like a married woman dies within 7 years of her marriage because of like unnatural reasons, not like because she was sick or she was COVID positive or something, but might be because of some burn injury or something, court presumes, or if there was like dowry demand beforehand, court would presume that it's case of a dowry death only. That is nothing but presumption of law based on the situation.
Yeah, but compared to civil, can you give me an example of presumption law?
Yeah, civil bill of exchange is only civil. The person has sort of violated it.
Okay, this is regarding instrument.
Yeah, instrument. Yes, instrument. Like check bounce is criminal, but this one is civil only.
No, civil. Okay. Yeah, okay.
Yeah, because it is considered just like a contract only, you have violated.
Criminal case, yeah, right.
So this is nothing but presumption of law. If court is already presuming in your favor, you don't need to give any proofs unless and until the party has clearly denied it. In such a case, you need to prove. Like if the party says that, yes, there is a signature in bill of exchange, but this is not my signature, it is a fake signature. In that case, you might need to give your points.
So that is the defendant had to prove that.
Yeah, the other party. There sometimes court would even ask for this, right? Handwriting expert and all, they would ask. Yeah. So
this clause gives the benefit of doubt to the plaintiff, saying that whatever he's saying is correct.
Either party. Okay, this is in neither party, right? If for plaintiff something is there, for defendant something is there, you don't need to give an explanation for that.
Okay.
Pleading to be signed. So every pleading shall be signed by the party and his pleader, if any, provided that where a party pleading is by reason of absence or some other good cause unable to sign the pleading, it may be signed by any other person who is duly authorized by him to sign or to sue or to defend himself. Sometimes it may happen that an agent is filing a case, or it might happen that on behalf of a company case is being filed, there are like two owners of the company. One of the owners might sign. So like that also it may happen. If someone is for any reason not able, somebody else might also sign, or otherwise the person will only sign on the pleading.
But the GP has to be given, isn't it, madam, for that?
Sorry?
GP has to be given for that. They can't just simply sign, isn't it?
The client simply?
No, the pleading has to be signed by the person who is submitting, or is the agent. But he can't simply sign unless there is an authorization like a GPA and all that, right?
Yes, unless and until he is authorized.
Yeah. But what does it mean by this, madam? Pleader is generally advocate signs.
Yeah, generally.
If pleader doesn't sign also, it's okay?
No, sometimes it might happen that the person says that no, I want to, like fight my own case. In that case, he may be allowed.
The party in person, okay.
Yes.
Okay.
Next one is address for service of notice. Now, when a case,
a party in person, should we file an application before?
For which one?
Suppose if I want to file a case party in person, what is the procedure?
I don't think you need to file like an application before, like the option is being given, right? So the person can simply, just like normally how institution of suit would happen, he can just submit his pleading.
Okay.
Yeah. So 14 clause A talks about address for service of notice. Now, when a case is being filed, it would continue for a while. So it would continue for a while, and there might be situations. Okay, so there might be situations wherein certain notices or some information needs to be sent to the parties. Okay, so for that we need address. Proper address has to be mentioned by the party as well. So it talks about the address for serving of notice. What is like the registered address of the parties? So when they are submitting their pleading, they would also mention their proper address, correct, complete address, that this is where notices may be sent to us, and that would be considered as the registered address of the party where all the information would be sent. And it might happen that they want to change their addresses. So for that, they can make a request and they can make the necessary changes. Okay, service of any process may be effected upon a party at his registered address in all respect as to such like residence. He would provide the address, there everything would be sent. Now,
but these are connected to order 1, 2 also, no, madam. One also stresses that, isn't it?
Which one?
Order 1.
No, it is about the pleading. What is pleading that order 1 talks about? Rule 1. Yeah.
No, in order 1 also, parties address, everything is there, no, madam, in the
parties address, yes.
Order 1 and 2 is also connected to this, isn't it?
Yes.
Yeah. Same thing, order 1 and 2 also talks of.
So regarding notice, it mentions, that notices would be sent to this registered address only. Now, sometimes it may happen that it is very much like obvious for the court to understand that this is like an incomplete address, some false address, or like a fictitious address that they have provided. Because court would work like within this territorial jurisdiction, they might be knowing that, okay, this certain places are there. So if court itself realizes, or if somebody files an application and says that this is not a proper address, this is like a fake address, okay, on application of party, in such a case, what court may do, that is being provided. Okay, in case such registered address was furnished by the plaintiff. who is filing the case, he has only provided like a fake address or an incomplete or a false address. Court may say that we are putting stay on this suit. This suit would not proceed unless and until you provide like proper complete address to the court. Or in case if it was defendant, court would say that whatever defenses you have provided, those would be struck or out unless and until you provide the proper address. So in such a case, proper address may be provided by the plaintiff or the defendant. And after furnishing the proper address, they can again ask the court that now we have provided, please like remove the stay or just accept the defenses. And if court is satisfied that the party was prevented by any sufficient cause from filling the true address at the proper time, will set aside that stay order or the order of striking out the defenses on such terms as they cause or otherwise as he may think fit, shall appoint a day for proceeding with the suit or defense as the case may be. So court may even like allow it if they are having like a valid reason to believe that yes, the party was genuinely having issues in proceeding with it. Okay. Then comes verification of pleading. Now, a lot of things would be written in the pleading in different paragraphs, mentioning different facts or matters that the person is claiming. So it is very much important that the party verifies it as well. So every pleading shall be verified at the foot by the party or by one of the parties pleading or by some other person proved to be to the satisfaction of the court to be acquainted with the facts of the case. They can do the verification at foot of the pleading. And whoever is verifying by reference to the number of paragraphs, because all the paragraphs would talk about specific things. Somewhere it may state that there was a contract between the parties. Somewhere it may state that one party performed his part. Another paragraph might say the other party did not perform. So all those paragraphs would be given, like numbers would be given for paragraphs. So they would mention these paragraphs, that paragraph 1 to 6, he verifies of his own knowledge. I am aware of this situation, so I'm verifying it. And what he verifies upon information received or believed to be true. Some other things he might not be having knowledge, but it may be that the advocate has informed him. Maybe advocate has informed that this is the right court where jurisdiction is there, so we are filing this case. Like that also there would be one point that parties would mention. Yeah. So there the person may say that this is like some information that I have received and I believe this information to be true. Next one is the verification shall be signed by the person making it and shall state the date on which and the place where he has signed it, because some information might be he was only having like incorrect knowledge or incorrect information. At what point in time the signature is done, date and all also he will mention. Next one is verification of pleading in commercial suit. So every pleading in a commercial dispute shall be verified by an affidavit in the manner prescribed in appendix to this schedule. An affidavit shall be signed by the party or by one of the parties to the proceeding. Where the pleading is amended, the amendments must be verified. First of all, the pleading is verified. After that, if with court's permission there are any amendments, there are any changes, those also have to be verified. Where a pleading is not verified in the manner provided, the party shall not be permitted to rely on such pleading as evidence of any form. Like other person may say that, okay, these claims you have not mentioned in your pleading. Defendant may say that you have not mentioned these things in your pleading, but plaintiff cannot use that as sort of like a defense that I have mentioned these things. Based on that, defendant has also sent these replies. Those would not happen.
Madam?
Yeah.
See, this verification, the normal verification in civil suit is verification we put at the end. Now this you said commercial verification, it has to be done on affidavit.
No, here also we have it. The person verifying the pleading shall also furnish an affidavit in support of the pleading. Affidavit
now,
is
verification of pleadings in a commercial disputes, why that is why there is a separate thing for commercial disputes? Commercial disputes is civil disputes, also commercial disputes, no, madam?
Yeah, commercial disputes only, but for commercial disputes, usually high courts would provide some rules and regulations, or for commercial dispute, there may be like a separate court which is there, like a commercial court might be set up.
Commercial dispute is like what disputes, madam?
Civil only.
No, civil, what is the difference between civil and commercial disputes?
Commercial as in it is basically related to some business transaction or commerce. In case of civil, it includes all the different types. Like in civil, we have labor matters, then there are some claim applications, there might be some title suits. We have different varieties, right? Like that.
So not connected to property as such.
Not connected to property. It might be connected to property, it might be connected to recovery of money, lot of things, but commercial thing has to be there, like related to trade and commerce it should be.
Okay.
Like based on if a contract is there between two parties, based on that contract, one had to make some payment because of some business transactions, those all would fall under commercial matter.
Okay.
Striking out pleadings. So at any stage of the proceeding, when the court comes to know that, okay, this is the pleading that is being filed, right? So the proceeding order to be struck out or amend in any manner in the pleading. Court may also ask that you need to struck out these certain provisions from the pleading, or you need to make certain amendments in the pleading. Usually it happens when court feels like whatever claims I am mentioning in the pleading, only those claims would be satisfied. If I have said that I need compensation for this certain thing, court would not provide me injunction or some other relief. Whatever relief I have asked, only that relief court would provide. So if at any point in time court feels that maybe whatever relief I'm claiming in the pleading, that is not proper, court may ask me that you make these changes in your pleading and you mention that you want injunction, or you want injunction plus compensation, like that court may ask at any stage of the pleading. And we usually get provisions of this in Specific Relief Act. Lot many times there are mentions like section 21, 22, 40 of Specific Relief Act. It talks about power of the court to ask for changes in the pleading as well. So if there are some unnecessary things, those court may ask that you remove it. There are certain things which would hamper in fair trial of the suit, those court may ask to remove, or otherwise if it is some sort of abuse of the process of court, then court also asks that you remove this certain points or you make this certain changes. Okay, then amendment of pleadings. Once we have submitted the pleading also, after that we have the option of making some changes, but it will not be done based on like whenever the party wants to do it, but it will be done with the permission of court only. So if the court is satisfied, then court may allow for amendment in the pleading as well. Either party to alter or amend his pleading in such manner on the ground. So the court may allow it. These are again the sections that you can refer from a Specific Relief Act also, where court can ask for amendments. And if court is allowing or has accepted this application for making amendments in the pleading, we need to do it based on the time limit which is being prescribed by the court. If there is no time limit which is mentioned, then within 14 days, we need to make those changes. And if we are not able to do it, like within this permitted time frame, then it's like, yeah, unless and until court is accepting, we cannot make the changes. Okay, so this talks about failure to amend after the order. Within the time frame prescribed or within 14 days, we are expected to make the changes as well. Okay. This part is clear, right? Pleading?
Yeah.
Okay. So for this plain and written statement also, I think we have two separate provisions. So we will continue with that in the next class. Okay. Plain and written statement part.
Madam, what is the type of questions comes on these pleadings?
Some essentials of pleading or what things.
It will be a short note or it will be a full-fledged question?
No, full-fledged questions also you may get, like what are the things that should be kept while, submitting the pleading, what all provisions apply, like that. There might be question where you can just mention the important points that these are the things that parties need to obey or keep in mind while filing pleading. Or there may be short questions also, write a short note on pleading where you can just mention on it.
But we are not, so see, it is not possible to remember rules, but generally, what are these pleadings? So we can put the points, isn't it, ma'am?
Yeah, if they are saying that what are the things that parties need to keep in mind, or what are the, important things in pleading, then you can simply mention that, okay, parties need to mention only the fact, not evidence. Parties need to do this, like that, point wise also you can mention.
No, but do they expect us to remember the rule and the corresponding statement?
Rules, see, everything is definitely not possible. So order you can mention here and there for some important things. Like take for example, rule 2 is important, material fact. Like that, 1 or 2 rules you may remember. Okay, so like all the rules might not be necessary.
Okay, ma'am. So you send these notes to madam now.
Yeah, fine. I'll share it.